Good evening. This is the January 25th meeting of the Constitution Meetup Group of Austin, Texas. And I'm here with you this evening. I'm Jon Roland. And we have with us Lela Pittenger.
Hello.
And we're going to be conducting a conversation on several subjects, starting with the proposed nullification legislation that I've come up with. On the 16th, we had a Tea Party type rally here in Austin on the south steps of the Capitol on the subject of nullification. There were about perhaps 600 attending. People were very excited about the concept. So I naturally got to thinking, maybe this is a time to dust off some of my old ideas on the subject and to put them forward. It turns out there have been several bills introduced by state legislators in various states to quote, nullify, unquote, unconstitutional federal legislation. The occasion in which this was done before, which is often cited for supporters of the concept, was done in South Carolina in 1832 in response to the so-called Tariff of Abominations of 1828. That tariff gave a preference to the merchants and manufacturers of the northern states and greatly disadvantaged the southern states. At the time, the southern states objected to it on the grounds that it violated the Constitution and its requirement that any legislation or taxation be for the general welfare and not favor one region or state over others. So they objected to it on constitutional grounds. Of course, they also objected to it on economic grounds, but the argument they made was that it was unconstitutional. The South Carolina state legislature adopted a bill, or they call it an ordinance, of nullification, which was based on the idea of nullification that had first been developed by Thomas Jefferson in the Kentucky resolutions of 1798. That was in response to the Alien and Sedition Acts. The Kentucky resolutions of 1798, which were another version of which were enacted the next year in 1799, have often been cited as the classic statement of the Jeffersonian interpretation of the Constitution. Because one of the things that it did was to lay out what powers delegated to Congress provided authority for criminal legislation. And it did not include things like the criminal penalties that were included in the Alien and Sedition Acts, but it would later be seen not to include criminal penalties for failure to pay a tax, or for doing a lot of the other things that were then being planned. So, the 1832 Act created a crisis. It was a crisis in large part because at that time the central government depended on the states to help them enforce their tax laws, their tariffs. And without the cooperation of state officials, they would be almost unenforceable. And without the support, of course, of local juries, they would also not be enforceable in court. So with the state legislature taking the lead in declaring the tariff unconstitutional and therefore null and void, that's hence the name, the word nullify, it was setting up South Carolina to be at odds with the central government. The crisis, it's called the Nullification crisis, was headed off when Congress, the U.S. Congress, voted to greatly reduce the tariff. And they made other concessions to South Carolina and other southern states to head off the crisis, and the nullification ordinance was allowed to expire. But it did set a pattern which people look to today. The most recent efforts in this regard have been things like state resolutions proclaiming that it shall be illegal to require anyone to purchase insurance under a federal program with such a requirement. The bills mostly don't contain much in the way of enforcement. There was one apparently introduced in New Hampshire which would require criminal penalties of federal agents who might try to enforce such things. And as I pointed out, that's not going to work for several points of view. The problem then is there a way for state legislatures to put pressure on Congress to either repeal or not enforce unconstitutional federal legislation? What I've come up with, which is on the wall here next to us, but I won't turn the camera right now to show it, we'll insert it later, is the notion that a state legislature, while it can't really pass an act to make it illegal for federal agents to enforce federal statutes, it can require all state officials and agents not to cooperate in its enforcement. In other words, they can require non-cooperation. And they can also urge citizens of the states not to cooperate. So that with the leadership of the state legislature, and of course the governor who has to sign off on it, you could have an organized civil disobedience that would be statewide, which, among other things, might make it very difficult to get a jury that would convict if there was either civil litigation or criminal prosecution.